Well, welcome to my new surroundings. No more Zoom. Now I'm on StreamYard, kind of learning as I go here. This video is about Chille DeCastro's May 23rd, 2024 hearing before Judge Levitt, looking to get permission to go beyond the 10-page limit for the appellate brief. The appellate brief, when you subtract off the front page and the last page, which is a proof of service, is 29 pages. I was wrong. I thought fast track rules applied, which limited to 16 pages because I'm not a Nevada lawyer. Turns out the Justice Court has its own rules of civil procedure, own court rules, I'm sorry, and it limited it to 10 pages. So now we're, way over the limit, okay? Now he filed this, it turns out, with the brief, the appellate brief. So, and maybe that's the custom in Nevada, but I like to seek permission before I do something. I don't like seeking forgiveness because what if the judge says no to this? So let's take a look at the actual document that was filed. It was all of 4 pages, and it even cited to technically the wrong code section. All right, so here are the Justice Court rules. So it's really 75 lowercase b1, not capital B. And except by permission of district court, briefs shall not exceed 10 pages. And it looks like it does. The people's brief is due 30 days after this brief was submitted, which would be around June 6th. Oral argument possibly. And then powers of district court, basically pretty broad. They can order a new trial. They can affirm, deny, but there won't be a retrial at the district court. And it includes all matters since the judgment, which would be all post-trial matters too. It should be saying a notice of motion and motion. This is notice. Here we have the comes now. I don't really think that's the right way to go. Also, I don't like all capitals, reads like a ransom note. And this is really supposed to be a lowercase b because we have statutes that actually have letters after them. And as part of the number, 75A, for example, in the Justice Court rules, or 76A. So when you have a capital B, people are thinking it's part of the number when it really isn't. So it kind of threw me off a little. So basically repeat itself again with the legendary numbers in parentheses. You'd think that a district court judge or any judge would understand that 29 means 29. And in contracts, you could write it out and then spell it just so that there's no misunderstanding that 10,000 is not 100,000. That's understandable. Anyway, they went 19 pages over, so they need permission. The undersigned may ask for permission. I don't think you may be asking permission. I think you're definitely seeking permission. So I don't know why you would said may ask. It means you may not. In support of this request, the infamous sentence interrupter, you could just take those out. The undersigned notes, you don't really need to note anything. You can simply go with Mr. DeCastro and eliminate all this extra superfluous words. Case raises extensive constitutional issues that were not raised. So we have raises and raised within the same sentence. At trial or during pretrial proceedings. Notice the same cadence. The name starts and then it's usually passive and passive voice. Okay. Numerous significant constitutional issues. Here it was extensive constitutional issues. Well, what is it? Is it extensive? Is it numerous? And when I looked at the brief, I thought maybe it was less than 6 items or 7 items. That wouldn't be numerous or extensive. And once again, we need to close with, things that are not, quoted correctly. And then, of course, the infamous number after the number is already stated. So, the next question is how would Judge Levitt receive this? Well, she's clearly going to have read the brief before they show up. Most judges are going to take kindly to the attacks on Judge Zimmerman, very out of bounds for an appellate brief. They also threw Michael Me under the bus in this brief, but at the same time, he's a counsel of record for the district court case against the cops in federal court, and he was listed on the notice of appeal. So explain that one to me. How can you be ineffective? You're still using him. Okay. They went so far over the limits, unless this is customary. A lot of courts like to hold to the rules because then everybody starts just violating the rules. People will say, well, if they get 30 pages, I get 30 pages. And then, now it's 60 pages instead of 20. There's a lot of things she could do here. She could even say, for example, that, I'm striking the brief. You're going to resubmit a new brief and the briefing schedule is going to continue on. Or what does she do? She just strikes the brief and says you can't file another one. I don't think that will happen. I mean, that would be pretty drastic. But this is a problem. And I don't know. Because the brief itself is so unpersuasive. It meanders. It just doesn't really hit the right issues, and it doesn't even spell out the constitutional challenges very well at all. It eliminates Wilson. It doesn't talk about Hibbert. It talks about the cases I did. This was their shot to change these two statutes. My information would help Chille, but I was looking beyond him. He was the guy that had the means to fight these statutes, just like I did in Orange County. I dealt with a lot of poor people who would never have the money to mount a legal challenge to anything. They ultimately get charged with obstruction. They ultimately plead guilty to it. And that's a lot of power to hold over people, especially when the statutes are so vague that they can sue innocent people as well. So that was my motivation, the greater good. So we'll just have to see. I don't really have a prediction on this other than she just might say that you're going to have to scale this back. I'm not going to give this to you, but I don't know. It's a very odd situation. We'll see.